Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Can a property owner block an easement on their property? This is a question that causes a lot of confusion and conflict between neighbors. The short answer is almost always no. If a legally valid easement exists on your property, you generally cannot block it or unreasonably interfere with the easement holder's right to use it. An easement is a legal right for someone else to use a portion of your land for a specific purpose, even though you own it. The property that benefits from the easement is called the dominant estate, and your property, the one being used, is the servient estate. As the owner of the servient estate, you have a legal duty not to interfere with that use. So, what counts as blocking an easement? It could be anything from putting up a locked gate across a shared driveway, building a fence that cuts off a path, or even constructing a shed or planting a row of large trees on the easement area. If you do this, the easement holder has the right to take legal action against you. They can get a court order, called an injunction, forcing you to remove the obstruction. You could also be liable for any damages they incurred because of the blockage. There are several types of easements, and they are all legally binding. You might have an easement for a utility company to access power lines, an easement for a neighbor to use your driveway to get to their landlocked property, or even what's called a prescriptive easement, which is created when someone uses a part of your property openly and continuously for a number of years. Now, are there any situations where an easement can be blocked or removed? Yes, but they are specific and require a formal legal process. An easement can be terminated if both property owners agree to end it in writing. It can also be terminated through merger, which happens if the same person buys both the benefiting and the burdened properties. Another way is through abandonment, but this is very difficult to prove. The easement holder must show a clear, physical action that demonstrates their intent to never use the easement again. Simply not using it for a while isn't enough. Finally, an easement created out of necessity, like for a landlocked parcel, may be terminated if the necessity no longer exists, for example, if a new public road is built. Before you even think about putting up a fence or blocking access, you must do your homework. Check your property deed and title report for any recorded easements. If you're unsure about your rights or the scope of the easement, it is crucial to consult with a real estate attorney. Taking matters into your own hands can lead to an expensive lawsuit. Thanks for watching. We hope this information was helpful. If you learned something today, please consider liking this video and subscribing to our channel for more content on real estate and property law.